Think your divorce lawyer is protecting you? Think again. Most people believe the papers in front of them are just standard forms, that signing them is the fastest way to move on and start fresh. But here's the truth nobody tells you: divorce papers aren't designed to protect you. They're designed to move the process forward, quickly, efficiently, and often at your expense. Buried in those pages are traps that can strip you of your rights, drain your bank account, and lock you into custody arrangements you never agreed to. And once you sign, undoing it is almost impossible. I know you're exhausted, and all you want is peace. I get it. But rushing through these documents is the one mistake that could cost you everything you've worked for. This isn't about being paranoid, it's about being prepared. Because the courts, your spouse, even your lawyer, they may not be looking out for your future. So before you pick up that pen, let me show you the hidden dangers inside those papers, the dangers divorce lawyers don't want you to know. Because if you think signing is just a formality, wait until you hear what's really inside. And if you're going through this right now, hit subscribe, because I reveal the traps divorce lawyers never tell you about. First, never sign a waiver of financial rights without fully understanding it. Now, I know what you're thinking. It's just one sheet of paper. How bad can it really be? But here's the truth nobody tells you: that single page could be the most expensive mistake of your entire divorce. Here's why. Buried in that waiver is often language saying you give up your right to alimony, your right to retirement funds, and sometimes even your right to future assets you don't even know exist yet. And once you give those rights away, you're done. Finished. The American Bar Association warns that courts almost never let you undo it. Judges look at your signature and assume you read it, understood it, and agreed. No take-backs. Let me give you a real-world example. Imagine you've been married for 15 years. During that time, your spouse built up a retirement account at work worth hundreds of thousands of dollars. You think, that's their money, not mine. I'll be fine. But what you don't realize is that under most state laws, retirement funds earned during the marriage are considered marital property. Which means, legally, they belong to both of you. By signing that waiver, you just handed over half a retirement account that could have secured your future. Now, here's the part that hurts most: once you sign, it's gone forever. Years later, when bills pile up, or when you realize how expensive single life really is, you can't run back to court and say, "I didn't know." The judge won't reopen the case just because you had second thoughts. And it's not just retirement. Alimony, also called spousal support, is another right people unknowingly waive. The Mayo Clinic and APA both emphasize how divorce often leaves one spouse, especially the stay-at-home parent, at a serious financial disadvantage. Alimony exists to help you transition and stay on your feet. But that waiver? It could strip away your safety net before you even know how hard the fall will be. I've seen people give up support because they were told, "Don't worry, you'll be fine. You'll get child support. You'll make it work." But child support is for your kids, not for you. Without alimony, you might find yourself working 2 jobs just to stay afloat, while your ex enjoys the retirement account you helped build. Now let's talk psychology for a second. When you're sitting in that lawyer's office or in mediation, you're exhausted. You've been through fights, sleepless nights, maybe even betrayal. You want it to be over. That's when mistakes happen, because you'll sign almost anything to get the pain behind you. That's exactly why these waivers are slipped in quietly, almost like background noise. And that's exactly why you need to pause and say, "Hold on. I'm not signing until I know exactly what this means for my future." Because here's the reality: signing a financial waiver without understanding it isn't just about money. It's about your stability, your independence, and your ability to rebuild after divorce. And no matter how strong you are, rebuilding is a lot harder when you've accidentally handed over the very resources that could have given you a fresh start. So let me say it clearly: never, ever sign a financial waiver until you've sat with a licensed divorce attorney and walked through every line, every clause, every consequence. Even if your lawyer or mediator says, "Don't worry, it's standard," your response should be, "I'm not rushing. Explain it. Show me. Prove to me this won't hurt me later." Because here's the hard truth: divorce isn't about what's fair, it's about what's written. And once it's written and signed, it becomes your reality. And if you think the financial side is the only danger, if you think money is the only thing you could lose, you're in for a shock. Because the custody clauses, they look innocent, but they can be even more misleading, and even more heartbreaking. Second, don't blindly agree to custody language. Now, for every parent watching this, listen carefully, because this is the part that can break your heart if you're not careful. Most parents hear the words joint custody and think it means 50-50 parenting time. Equal nights. Equal weekends. Equal holidays. Sounds fair, right? But here's the hidden truth: in most states, joint custody doesn't guarantee equal time at all. Legally, the term usually refers only to shared decision-making authority. In other words, both parents have a say in big decisions, like education, healthcare, and religion, but the actual number of days your child spends with you could be far less than you expect. The U.S. Department of Health and Human Services warns that custody and parenting agreements must spell out the details: visitation schedules, pick-up and drop-off times, holidays, birthdays, school vacations, and even how decisions will be handled if you and your ex can't agree. If those details aren't written down, you don't have a plan. What you have is confusion, and in most cases, disappointment. Here's the danger: if you sign vague custody language, you may think you've secured equal time, only to realize later that your joint custody means every other weekend and maybe one dinner during the week. That's not equal parenting. That's being a visitor in your child's life. And let's talk about what that feels like. Imagine tucking your kids into bed only 4 nights a month. Imagine missing birthdays because the calendar wasn't specific. Imagine your ex suddenly refusing holiday swaps because the papers didn't mention them. That's not just paperwork, it's years of lost memories, years you can never get back. And here's the hard truth: once you sign, courts rarely change the arrangement unless you can prove a major shift in circumstances, or worse, that the agreement harms your child. That bar is very, very high. Which means the vague clause you signed today could define your parenting life for the next decade. Now, you might be thinking, but my ex and I get along fine. We'll figure it out. That may be true today. But divorce changes people. New partners, new jobs, new homes, they all create tension. A once friendly co-parent can quickly turn rigid, and when that happens, the only thing that matters is what's written in black and white. That's why experts recommend building parenting plans that cover everything: school pickups, extracurricular activities, communication rules, even how you'll handle future disagreements. It may feel uncomfortable to be that detailed, but trust me, it's far more painful to find out too late that the details were missing. Here's something most lawyers won't tell you: vague custody language often benefits the parent who already has the child most of the time. Why? Because in practice, possession is power. The parent who physically has the child sets the tone, and unless you have clear language to challenge it, you'll be left fighting uphill battles. And let's not forget, this isn't just about your rights. It's about your child's stability. Kids need predictable routines. They need to know when they'll see each parent. They need holidays they can count on. A vague agreement doesn't just rob you of time, it robs your kids of certainty. So before you sign, demand clarity. Demand details. Demand a schedule that spells out exactly what parenting time looks like. Don't accept vague promises or assumptions. Don't accept, "we'll work it out later." Later never comes. Later is when the fights begin. Because here's the truth: custody papers are not about trust. They're about protection, protecting your time, your bond, and your child's right to have both parents present in their life. And if you think custody is the only landmine in your divorce papers, think again. Because hidden inside property division is a clause that sounds harmless but can rob you blind. Let's talk about that next, because property agreements come with a nasty surprise you do not want to miss. By the way, if this opened your eyes, hit subscribe right now. I break down the divorce secrets lawyers and courts don't want you to know, so you stay protected. Third, beware of blanket property clauses. Now, this one is sneaky, because on paper it looks innocent. You'll see language like, "all property has been divided to the parties' satisfaction." And at first glance, you think, great. We've split things up. Done. But that single sentence can be one of the most dangerous traps in your divorce papers. Here's why: when you sign that kind of blanket clause, you are essentially declaring to the court that everything has been divided fairly, that you've seen all the assets, and that you're satisfied with what you got. Sounds simple. But what if you're not? What if your spouse hid a savings account, or stock options at work, or even something as big as a piece of property you didn't know about? According to the National Association of Divorce Financial Planners, once you sign that clause, going back to court to reopen the property division is extremely difficult. Judges don't like to undo finalized agreements. They see your signature, they see the wording, and they assume you agreed with full knowledge. That means, even if you later discover your ex hid assets, you may be stuck with the deal you signed. Let's make this real. Imagine your ex had a retirement account you didn't know about. Maybe it wasn't listed on the disclosures. Maybe it was accidentally left out. If you signed a blanket property clause, your chances of reclaiming your share are slim to none. That's hundreds of thousands of dollars, money you earned a right to during the marriage, gone forever. And it doesn't stop at retirement accounts. Hidden bank accounts. Bonuses at work. Stock grants. Real estate investments. Even valuable collections, art, jewelry, classic cars. If it's not disclosed and you've signed that blanket language, the court will assume you knew and agreed. Now, here's where empathy matters. I get it. You're tired. You've sat in mediation for hours. You've argued over furniture, pets, maybe even the dishes. By the time you reach that final property section, you just want it over. That's when people let their guard down. That's when they sign off on vague wording just to get out of the room. But remember, your exhaustion today can become your regret for the next 20 years. So how do you protect yourself? Number 1, insist on specificity. Every account, every property, every asset must be listed. Not just all property divided fairly. No. It should read like an inventory: this account goes here, this property goes there, this vehicle to you, that vehicle to your ex. The more detail, the safer you are. Number 2, don't rely only on trust. Use discovery tools if you have to. In many states, you can request financial disclosures, tax returns, bank statements, and retirement records. If something feels off, dig deeper. Remember, divorce isn't about trust. It's about protection. Number 3, if your spouse refuses to disclose something, that's a red flag. Push for it. Don't assume the court will magically catch it later. They won't. Judges don't go digging through your ex's finances. They look at what's presented and what you sign. Period. Here's the mindset shift you need: signing a property clause isn't just the end of your marriage, it's the blueprint for your financial future. If something is missing, your future will pay the price. And here's the bold truth: I've seen people walk away from marriages with nothing but their clothes, while their spouse secretly sat on assets worth hundreds of thousands. Why? Because of one vague sentence: property has been divided to the parties' satisfaction. Don't let that be you. Don't let fatigue, pressure, or promises push you into signing away what you're entitled to. Be thorough. Be detailed. Be relentless. Because here's the thing: if you think dividing property is complicated, wait until you see what's buried in the debt section. That's where the real financial landmines are hiding, and signing that part without understanding it could destroy your credit, your stability, and your peace of mind. Fourth, never assume debts are automatically divided fairly. Now, if the property section was a minefield, the debt section is a ticking time bomb. Because here's the truth: creditors don't care what your divorce decree says. You can write in bold letters that your spouse is responsible for the car loan, the mortgage, or the credit card, but if your name is on that account, you're still on the hook. The Federal Trade Commission is clear about this: if your name is on a loan or credit line, you are legally liable for it, no matter what your divorce papers say. That means if your ex misses payments, racks up late fees, or simply decides not to pay, guess whose credit score takes the hit? Yours. Guess who the collection agency calls? You. And it doesn't stop there. Imagine this: you and your spouse had a joint credit card. The divorce decree says they're responsible. Fine. But 6 months later, they're behind on payments. Suddenly your phone is blowing up with collection calls. You pull your credit report, and your score has dropped 100 points because of their mistakes. That can ruin your ability to rent an apartment, buy a car, or even qualify for certain jobs. And the worst part? The court won't rescue you. The creditor doesn't care about your divorce decree, they only care about the contract you signed with them. Let me give you another example, a mortgage. Say the decree says your spouse keeps the house and is responsible for the mortgage. But your name is still on the loan. If they stop paying, the bank comes after you. You could be sued for foreclosure, even if you moved out years ago. Here's the bold truth: I've seen people go bankrupt because they trusted a piece of paper over financial reality. They thought, the judge assigned this debt to my ex. I'm safe. But when payments were missed, their credit was destroyed, their wages garnished, and their financial future wrecked. So how do you protect yourself? First, whenever possible, get your name off joint debts. That means refinancing loans, closing joint credit cards, and removing your name from accounts before the divorce is finalized. If your spouse is keeping the house, push for them to refinance it into their name only. If they can't, consider whether keeping them on the hook is worth the risk. Second, don't just trust words on paper. Ask for proof. If the decree says your spouse will take responsibility for a debt, make sure the account has actually been switched out of your name. If it hasn't, you're still legally tied. Third, monitor your credit. The FTC recommends checking your credit report regularly during and after divorce. That way, if your ex slips up, you'll catch it before it snowballs into lawsuits and ruined credit. And here's something most lawyers don't emphasize: debt division is not about fairness, it's about enforceability. The court can order your spouse to pay, but creditors won't honor that order. The only way to truly protect yourself is to separate accounts and remove your name. Period. Now, I know what you're feeling. You're thinking, but I don't want to fight. I just want this over. And I get it. You're tired. But let me be blunt, if you don't fight now, you'll be fighting creditors later. And believe me, creditors fight dirtier than ex-spouses. This is why financial experts warn: never walk out of mediation or court with your name still attached to debts you don't control. Because when the payments stop, the calls begin. And the calls don't stop until they've drained your wallet and wrecked your credit. So don't assume debts are divided fairly just because it's written in black and white. Protect yourself, separate accounts, and get everything in writing with creditors, not just the court. And if you think the debt section is terrifying, just wait. Because buried inside the fine print of settlement agreements are clauses so misleading, they can lock you into obligations you never intended. And once you sign those, there's no turning back. Finally, don't sign the settlement agreement without carefully reviewing every line. Why? Because this is the document that ties everything together: your money, your custody rights, your property, and your debts. Once a judge stamps it, this becomes law in your life. And here's the brutal truth: undoing it later is almost impossible. State bar associations across the country stress this: settlement agreements are legally binding contracts, far harder to challenge than temporary orders. That means if you later realize something's unfair, or you discover your spouse wasn't fully honest, the court will usually say, "Sorry, you signed it." Here's where most people lose the most. They're exhausted. They've been battling for months, sometimes years. They're drained emotionally, financially, and physically. And in that moment of weakness, they think, "I just want this over with." So they trust their lawyer, they skim the pages, and they sign. And that signature can lock them into financial and parental obligations that last a lifetime. Let me give you an example. I've seen cases where someone signed a settlement that said each party keeps the debts in their own name. Sounds fair, right? But guess what? They had co-signed for a car loan years earlier. When their ex stopped paying, the creditor didn't care about the divorce settlement. They went straight after the signer, wrecking their credit, draining their bank account, even garnishing wages. And because it was written into the settlement, there was almost no way out. Or worse, parents who thought they were signing for shared custody, but didn't notice a clause that gave their ex primary residence designation. That one line meant their kids lived mostly with the other parent. And when they tried to challenge it later, the judge said, "It's already signed. The child needs stability." Game over. So here's what you need to do. 1. Slow down. Never let anyone rush you into signing a settlement, no matter how much pressure you feel. 2. Read every line, even the boring ones. Because the boring lines are often where the traps are hidden. 3. Get a second opinion. Another lawyer, a financial planner, even a trusted advisor who's been through it. A fresh set of eyes can catch what you've missed. For ask yourself this: if I had to live with this agreement for the next 10 years exactly as written, would I still be okay with it? If the answer is no, don't sign. Because here's the reality: divorce isn't just a breakup. It's a business deal with lifelong consequences. And the final settlement agreement is the contract that determines your future. Don't let exhaustion, trust, or fear cost you your rights, your money, or your relationship with your kids. You fought too hard, sacrificed too much, and endured too many sleepless nights to throw it all away with one rushed signature. So when that final document is in front of you, remember this: signing smart is protecting your future. Signing blind is surrendering it. Before I summarize all 5 traps, let me know in the comments which one shocked you the most, because I guarantee most people have no idea about 3. Let's do a quick recap, because these 5 traps are where most people lose everything in divorce. First, waiver of financial rights. Never sign it blindly. Hidden in that one-page waiver could be language that strips you of alimony or your share of retirement accounts. Once you give that up, it's gone, forever. Second, custody and parenting time. Don't be fooled by fancy words like joint custody. In many states, that doesn't mean equal time, it just means shared decisions. If you don't spell out the exact schedule, holidays, and authority, you could see your kids far less than you expect. Third, the hidden property clause. Vague language like all property has been divided to both parties' satisfaction sounds harmless, but it shuts the door if your spouse hid assets. That bank account, stock option, or inheritance. Gone. And good luck trying to reopen the case later. Fourth, debt responsibility. Never assume the court protects you. Creditors don't care what your divorce decree says. If your name is on the loan, you're on the hook, even if the papers say your ex is responsible. That one mistake can crush your credit for years. And finally, the settlement agreement. This is the big one. It ties everything together: money, kids, property, and debts. Once signed by a judge, it's almost impossible to change. Don't let exhaustion or pressure trick you into rushing. Read every line, get a second opinion, and make sure you can live with it for the next 10 years. Here's the bottom line: divorce papers aren't just paperwork. They are contracts that will shape your money, your time with your kids, and your future. So never sign blind. Protect yourself, protect your rights, and protect your future. The truth is, this divorce papers aren't just paperwork, they are legally binding contracts, and once you sign, they shape your money, your kids, and your future. Most people rush. They're exhausted. They just want it to be over. And that's exactly when mistakes happen. Because what feels like just another stack of forms is actually the blueprint for the next decade of your life. Think about it: one unchecked box could erase your right to retirement savings. One vague custody clause could cost you precious time with your kids. One hidden property statement could shield your ex's assets forever. And one debt assignment could sink your credit score for years. Every line matters. That's why you cannot afford to skim. Don't assume your lawyer has caught everything. Don't assume the court will protect you. And don't assume standard language means safe language. The people who regret their divorce the most are the ones who rushed just to sign and move on, only to spend years fighting battles they could have prevented. So here's my challenge to you: slow down. Read every word. Ask every question. Demand clarity, even when it feels uncomfortable. And if something feels off, don't ignore it. Get a second opinion. You have one chance to get this right. Because protecting yourself now means fewer regrets later. Protecting yourself now means a stronger financial foundation. Protecting yourself now means more time with your kids, more control over your future, and more peace of mind when this chapter is finally closed. If you found this helpful, subscribe now. I post weekly videos exposing the truths about divorce that nobody else talks about, so you don't make the mistakes that cost people everything. And remember, this video is for informational purposes only and is not legal advice. Always consult a licensed attorney in your state.